Good afternoon, everyone, and welcome to the Smart Women Savvy Money 2010 webinar series. 30 minutes on the clock, 20 minutes to teach, and 10 to talk. We are so excited that we are going to be hosting the first of our three-part series on aging in place. For many of us as daughters, mothers, fathers, brothers, we have the responsibility of taking care of our elders. And I can't tell you how many times we've had scenarios and having conversations with clients asking for some solutions about how to deal with and navigate through this very, very difficult period that they are going through. And in many instances, they are having to navigate through taking care of elderly loved ones, as well as they may have kids that are entering college or are in college. So truly the sandwich generation in a lot of ways. And in other instances, we have many people who are looking ahead for themselves, trying to figure out how will they lead their lives into retirement and what kinds of things they can put in place in order to make their lifestyles easier and the lifestyle they desire and deserve. Before we get started with today's conversation, I just want to cover a few housekeeping items. As you can see from our screen here, if you haven't been to our website, please come to visit because we have a plethora of great information, educational pieces, and we think topics that are really relevant to everything that we are experiencing. As I mentioned, this is the first in our Aging in Place webinar series. And so today, there's Christine. Christine is our guest blogger, but she's also our speaker today. But we also have a tremendous amount of content on our screens and on our pages that we think you will find of great interest. Every other month we are hosting a piece called Your Life, Your Legacy, and in that we actually showcase and highlight an individual who is very active in the philanthropic space. And we're looking for people who are leaders and thought leaders in that space. And today, or for this month, for example, we have Vivian Lee, who is the founder of Vin Lee Consulting. Great stories, great women, and great opportunities. In addition to that, we also host, as you know, because you're on today's call, a number of different webinars. Our webinars are held the second Thursday of every month, except for the month of December. Next month, we will be hosting a great discussion on how to align your investable dollars with your values. Really a conversation around socially responsible, but more to the point, impact investing. How do you really make a difference? And how do you select the appropriate platforms where your dollars are going to make a major difference? For example, the speaker that we have next month is actually with Trillium. She spoke at our women's conference earlier this year, which was in January, and she is actually an advocacy representative for Trillium Asset Management, which is a socially responsible and impact investing firm. Her role is to make a difference with a lot of publicly traded companies, and some of their major initiatives right now, for example, are to promote gender diversity on boards and are pushing back against boards, for example, that are comprised solely of men, just as one example. So that should be a very, very outstanding talk, and we invite you to come back on that. Again, second Thursday of the month, that'll be June 8th. In July, we will have our second in the series of our Aging in Place talk, where we will have a realtor who has a certification in providing for and working with seniors. And then also in August, that will be the last of our talk, which is how do you manage your loved one's care, particularly for a lot of us who might live in another city or a state, and our loved ones are at some distance? How do you manage that from afar? So there's going to be some pretty interesting insights about how to do that. The rest of our year is pretty much filled out, so we invite you to come back to the website to find out more about what we have on tap. Now, having said that, what I'd like to do now is to introduce you to our guest speaker today. And we're really happy to be working with Christine because she is an amazing attorney who specializes in this space. And this has become a very, very big space to be in because of the needs of many of us who are trying to help and work with a lot of our loved ones. And as I mentioned also, preparing for our own lives and making a difference there. So first, let me start by saying that Christine is a member of the National Academy of Elder Law Attorneys and the South Bay, which here in the Los Angeles area is the beach cities. She's also a member of the South Bay Bar Association's Probate and Estate Planning section, and a member of a number of community organizations serving the needs of elder adults. Because of her strong commitment to personal attention, she and her law firm have been able to serve several generations within a family or different branches of the same family. She specializes in Medi-Cal long-term care planning, estate planning, which includes will, revocable trust, durable power of attorneys for finances, special needs trust for the disabled who might be receiving public benefits, conservatorships, probate administration, trust administration, and VA benefits. So a whole host of areas that she is actually able to assist her clients in. So with that, I am going to introduce you to Christine. And Christine, I am turning it over to you. Christine? Let's see. Christine? There you are.
Can you hear me now?
Yes, we can.
Wonderful.
Technology, isn't it a wonderful thing?
It can be, yes.
Welcome.
Definitely. Thank you very much. So I'd like to say hello and good afternoon to everyone, and thank you for joining me today at this webinar. And I'd also like to thank Renee and Diane at Urban Wealth Management for the opportunity to speak to you on this topic. So as Renee mentioned, I am an elder law attorney. So in my practice, I regularly see older adults struggling to do their own estate planning, as well as adult children who are trying to have this very difficult but very important conversation with their own parents. I see parents who are making the tough decisions about their estate planning, and also a few who use the inability to make a decision about their estate planning as a reason to procrastinate a little bit longer. And I also have clients who seek my advice on how to approach their parents about getting their legal affairs in order. So I feel everybody's pain in this situation. I wanted to start this webinar with a few statistics to show you that you're not alone if you've not had this very important conversation with your parents, or maybe you've had the conversation, but it didn't go as well as you'd hoped. So recently, Fidelity Investments did a survey of 221 parents over the age of 55 and their adult children. And in that survey, Fidelity found that 34% of the parents hadn't had a detailed conversation with their adult children about their living expenses in retirement, and 43% of the parents said they hadn't had detailed discussions about their long-term care plans. So you're in very good company if you've not had this crucial conversation with your parents, or if your parents have not initiated the conversation with you. So what are some of the barriers to having this conversation? I think people in society have created barriers to these types of conversations, and the barriers vary. They tend to revolve around deeply held beliefs that you don't talk about money and death. I find the most common reason people don't want to talk about their estate planning is because people don't want to think about dying. Let's be honest. Dealing with your parents' mortality is not an easy topic. And your parents also don't want to think about the fact that they may pass away. Adult children, despite being mature adults, don't want to think about their parents dying or becoming incapacitated, let alone articulating the possibility of that happening. Most of us who still have parents are thrilled, if not relieved, that they're doing well, and we hope that they live to be 120 and pass away in their sleep so we don't have to deal with their death or incapacity anytime soon. It's not uncommon for me to see an 80-year-old or a 90-year-old who hasn't prepared a will or other legal documents because it's not time yet. Well, when is the time? When you're in the hospital? That could be too late. I've also heard that if I set up my estate plan, I'm going to die. My joking response to that is estate planning attorneys don't work for the Grim Reaper. That's not how it all works. And while I am joking, I do understand that some people believe that if they deal with their mortality, it's like they're giving in to the fact that they will die. I like to say it's more like Murphy's Law. If you set up your estate plan, you will not need it for a long time. It's kind of like insurance. You complain about having it. You complain about the cost. But when you have insurance, because when you have insurance, not technically, but usually nothing happens to your car or to your house. However, like insurance, you're awfully glad to have your estate planning in place when a crisis hits. The second barrier may be that your parents don't want to face the possibility of having to give up control over their lives. The most important fact that you need to make clear to your parents is that estate planning will allow your parents to be in control. They get to decide who's in charge of their medical decisions, who's in charge of their finances, and ultimately who will inherit their estate, their legacy. If they fail to make those choices, the court, a judge who they've never met, who does not fully understand their family dynamics, will decide all of those issues for them. And it may not be the decision that your parents would have made for themselves. The third barrier could be your parent may have a sense of embarrassment if they haven't managed their money properly. You probably already know that your parents do or do not have a lot of money. You just need to reassure them that you don't care about the money they have, but that you want to maximize the money they have to ensure that they're properly cared for. And this can only be done by planning now rather than later. Parents aren't the only ones who are uncomfortable. Adult children may be nervous about raising the topic of their parents' finances for fear that they will appear greedy or nosy. In that same Fidelity survey, Fidelity found that when families talk, misunderstandings happen. 69% of the parents say they've discussed their will and estate planning with their children, but 52% of the children say that's not the case. Well, I'm no math whiz, but I'm pretty sure that those two percentages should be the same. So what happened there? A misunderstanding occurred regarding the word discussed or discussion. I'm pretty sure the conversation between parent and child went something like this. Parents created a will or a trust several years ago, if not several decades ago, and in passing mentioned that they had a will. Probably the comment happened as the parent was walking out of the room or as the child was hanging up the phone on a long-distance phone call. So that's the beginning and the end of the conversation. In that scenario, it's quite easy for an adult child to forget the conversation or maybe not even heard the conversation. The reality is that due to the miracles of modern medicine, mostly pharmaceutical drugs and medical procedures, our life expectancy has been extended. It's very common in my practice to have my clients being in their 80s or their 90s. Our quality of life is being extended, but not necessarily the quality of our life. If you can think back to 50 years ago or more, it was more like people lived, they died, and they passed away from a brief or a sudden illness. Now, that's not always the case, but that tended to be the case. Now we have people who are regularly living into their late 80s, 90s, if not 100, but they're not always living on their own. They're not always managing their affairs on their own. And how do we know that? Look at all the assisted living facilities, boarding cares, and skilled nursing facilities that exist. Look at all the people that you may know in your life that have dementia and Parkinson's. We see these patients living longer, or the progression of their disease to slow down. That wasn't always the case 30 or 40 years ago. So now, not only is your awkward conversation not only going to include asking your parents how they want their estate to be handled after they pass away, but you also have to ask them how they want to be cared for when they're incapacitated. You don't want your parents angry because you're anticipating your death, but now you have to tell them that you think that they're going to be incapacitated too, right? No, yep, very, very awkward conversation. I tell my clients, these are not Sunday dinner conversations that you have with your family. You don't say, Dad, can you please pass the gravy? And by the way, do you want to be buried or cremated? Or, Mom, this casserole is great. If you become incapacitated, who do you want to manage your finances? Your parents are getting older, but who isn't? We all are. It's a fact of life. But it's never too early to start talking with your parents about what-ifs and planning for what might happen in the future. It is best for your parents to have their affairs in order before competency can be questioned. Unfortunately, I get several calls a week from children who are well-intentioned who say, my parent has X, fill in the blank, dementia, advanced dementia, Parkinson's, a massive stroke, and I need to get their estate planning in order. Well, competency is the first, and depending on the answer, the last question we ask our potential clients. And 95% of the time, when we ask, is your parent competent, the question or the answer is, well, he or she can still sign their name. Well, that doesn't answer my question because merely signing your name is not sufficient indication that you can understand the terms of the legal documents that you're asking us to prepare. And these are all serious issues that can't be ignored because the burden of a lack of estate planning falls on the shoulders of the younger generation. That would be you and I, that has to pick up the pieces and make all the personal and financial decisions for your parents. And for your parents, it is very, very important to have their legal documents in place because it will make your ability to make the personal and financial decisions much easier. This is going to be a very stressful time in your life, and the last thing you need is to have to go to court to make these personal and financial decisions. So what are some icebreakers to start the discussion? Well, the easiest way is to lead by example. Talk to your father and say, guess what we did last week? We did our estate planning, and you know what? It wasn't that hard, and it gave us a peace of mind. We have documents in place to take care of us if we become incapacitated, and we've decided on how our estate will be distributed. It's a weight off our shoulders. Now our kids know how we want to be taken care of and who will carry out our wishes. And that can lead to the question, do you have your estate plan in place? Has it been updated? If your parents have an estate plan, for example, a will from 1980, it's imperative for them at the very least to get their estate planning documents up to date to reflect their current wishes. Another icebreaker can be, I just read this interesting article on estate planning. Tell your parents that you listened to a webinar or read an article or a blog post and ask them what they think. I mean, thank God for Google. It's easy enough to Google estate planning, and you will get thousands of articles on the topic to break the ice. Another way to do it is perhaps you have a sibling with special needs. Use that as the discussion starter. If your brother John has autism, you may ask your parents, who's going to take care of John if you're incapacitated? Ask them, do you know that there's a way to give John an inheritance and still keep him on public benefits, which is called a special needs trust? Give them an article about special needs planning. While a parent may not be willing to discuss estate planning with their able-bodied employed CPA son, they will be more responsive to protecting their autistic 52-year-old son, because if they're not able to care for him, they want to make sure someone else will be. And hopefully the follow-up discussion will open the door at least a little to some of the concerns and opportunities that you see. Have the right person start the conversation. Your estate planning conversation will be directly related to your family dynamics. Who in your family does your mom or dad relate to best? Is it the oldest child? Is it the youngest child? It may be an aunt or uncle, or it may even be a favorite son-in-law. If no one in your family wants to steer the talks, you may want to bring in a trusted independent party like the family lawyer, the CPA, the financial planner, or a close family friend. Parents may not want to take advice from their child, but if their financial planner says they need a trust, they may be more likely to go to an estate planning attorney to make sure that happens. Also, look for openings. It might just be an offhanded reference by your mom regarding her mortality, or when you're all together in the aftermath of a family friend's funeral. It's a great opportunity, not at the funeral itself, but for later on to talk about, I wonder if Bob had his affairs in order. Do you have your affairs in order? That kind of thing. And even your parent may bring that up if a family friend passed away. They may relate to you, wow, it's really easy for Mary to take care of the affairs after Bob passed away because they had a trust or they had other documents in place. Use that as an opportunity to talk a little bit more with your parents. Another icebreaker could be ask your parents for estate planning advice. You might say, hey, we're thinking about doing our estate planning. What do you think about this? And that can lead you to asking them, have you gotten your estate planning in place? You just try and turn the conversation about your parents. It's not about their money. It's about them and how they want to be taken care of. Because if they feel surrounded, they'll get very defensive. Just tell them, I need you to stay in charge, but at a minimum, I want to know where all the stuff is kept. And by stuff, we mean the legal documents, the assets. And then talk about what parts that you should know about. What do they feel comfortable talking to you about? You can also say, we want to make it clear, or we want to be clear on what your wishes are in terms of your estate. We want to make sure that we all understand what's important to you, and we want to do whatever is necessary to support you. We want you to be in control of your future. We want you to make those decisions for yourself. We don't want disagreements between us siblings to arise when a crisis occurs. But we want to keep this family intact when you, which is in essence the glue that holds everybody together, are gone. Include your siblings in the conversation. Even if a sibling or siblings don't want to be involved in the meeting with your parents, tell them what happened. If an estate plan is ultimately developed, tell your siblings what it says. Keep the communication open. If you're secretive, it will raise their suspicions and can result in a broken relationship with both you and your parents, or worse yet, they may try to take your parents to another estate planning attorney and develop another plan, which could just cause a load of future legal problems. So once the discussion is happening, what do you need to talk to your parents about? Well, number one would be long-term care preferences. Does your mom or dad want to live in a nursing home, or would they prefer in-home care if the need presented itself? If they prefer a facility, what amenities and activities are important to them at this point in their life? If they want to live alone in their home, will this suit their personality, or will loneliness and depression result? Do they want an attendant to take them out on outings? These are all questions that, if discussed in advance, can make the transition into an assisted living or a home health care program much easier on everyone when the time comes. The second one is current legal documentation. It's imperative that adult children find out what legal documents their parents have in place before incapacity occurs. This includes making sure that their parents have a financial durable power of attorney, a trust, a will, healthcare directive, and HIPAA, HIPAA documents, so someone can easily step in to make financial and medical decisions on their parents' behalf. And what type of estate planning document you will need will depend on the state you live in and what type of assets your parents have. So it's best always to speak to an estate planning attorney about that. Otherwise, if your parents don't have any legal documents in place, it may force the family to petition a court for control over their parents' assets. if they've passed the point of legal capacity. So make sure that the estate planning documents are current and up to date. It doesn't mean that you have to see an attorney, but look at your documents and see what they say. You may want to look at it and you realize, life happens, people change, your relationships with people change, and these are some reasons to update or change your estate planning documents. You may look at your documents and say, well, that executor that we named, I haven't spoken to him in 20 years, or that agent that we've named for medical decisions, they're incompetent too. So if you have documents and you have people in place that are no longer able to help you out, the documents will not be able to help you out when you need it. As a child, I would recommend you getting copies of the estate planning documents if your parents are willing to share that with you. If the parents say, no, I want to hold on to it, I'm going to keep it in the red binder in the bottom left-hand drawer of my desk, that's also good. But I have to warn you, especially if there's a diagnosis of dementia, I've had numerous families tell me that when they go back to the left-hand drawer and look for the red binder's gone. Just happened, wasn't anything bad, but mom or dad with dementia may have cleaned out the desk, not knowing what it was, and just threw it out. Now the kids can't find the estate planning documents. Don't fear. Go back to the estate planning attorney. I do in my practice, I keep signed copies of every document that my clients sign, so I have it. If your parent doesn't want you to contact the attorney just yet and gives you the attorney's name, great. There's always bar association websites. You just look up the attorney's name and their name pop up, and you'll be able to find them if they perhaps have moved since your parents did their documents. A third thing to be discussed with your parents is medical preferences and wishes. So I always encourage my adult children clients to find out what type and how much medical care their parents want after receiving a diagnosis of Alzheimer's or dementia. Do they have specific wishes about life support or other end-of-life decisions? Who do they want to make such decisions on their behalf? Do they want to be buried? Do they want to be cremated? If they want to be buried, where do they want to be buried? If they want to be cremated, where do they want their ashes scattered or placed? So these answers to all these questions will help your parents feel secure knowing their wishes will be carried out during an otherwise emotionally charged time. The fourth thing to think about is the current state of your parents' financial affairs. To ensure finances stay properly managed after a diagnosis of dementia or Alzheimer's, children should start asking tough questions about their parents' financial affairs. This includes finding out the location of any safe deposit boxes, bank accounts, investment or brokerage accounts, long-term care insurance, life insurance, outstanding debts, or other assets not known to the family. And in today's day and age, find out your parents' usernames and PIN numbers for online accounts. Make sure that if your parents do have a trust, that the assets that they own are titled in the name of the trust. And this goes for all non-retirement assets. They should all be in the name of the trust. Because if the assets are not in the name of the trust and your parent becomes incapacitated, you can't use that trust document to come in as a successor trustee and manage those assets. There's some additional steps that need to be taken. Also, confirm that your parents are taking the required minimum distributions from the retirement accounts. You'd be surprised how many elderly people don't realize that they need to do that, and they haven't been doing that. Make sure that your parents' beneficiary designations are up to date and current. Make sure that your parents have been filing the necessary tax returns. Make sure that the house or the rental property or the cars are all properly insured. Make sure the insurance is current, and make sure that the limits are correct on the insurance. Otherwise, if you don't take these types of steps, that some necessary assets needed to cover long-term care or other expenses could be overlooked when memory loss ultimately occurs, because your parents aren't going to be able to tell you that they have a bank account at Chase or that Renee is managing their money. If your parents are open to it, have them introduce you to their attorney, their financial planner, their accountant, their insurance broker. It's good for you to know all these people. That way you know how to get a hold of them in a time of crisis. Last but not least, have the important contacts and information. So while your parents' memory is still sharp, work with your parents to compile a list of important contacts and information that will be useful to you if memory loss occurs. This can include documenting key players on their team, such as doctors, professional advisors, accountants, attorneys, financial planners, and also, if they will allow you to, have a copy of their Social Security card, their Medicare card, any identification cards, insurance cards. That's also very important in a time of crisis. If your parent is going into a hospital, you're going to be asked for the Medicare cards. You're going to be asked for the insurance card. So it's always good to have a photocopy of that. And if your parents allow, have a copy, in your home or on your phone. The most important thing to remember is you need to focus on what your parents want, because this is all about them and making their life a lot easier if they lose their capacity or when they pass away. So keep the focus on your parents' wishes to make it clear that they will benefit from this conversation. And it's to help everyone feel more at ease about your parents' wishes. You can give constructive input about their estate planning, but don't force your opinion. If, for example, your mom wants to name your oldest brother because he's the oldest male child and doesn't want to hurt his feelings, to be the trustee of her trust and to make all of her medical decisions as well, you may want to point out that because he lives in Florida, he may not be the best person to deal with medical emergencies or care issues. I mean, if you see a problem, point it out, but you need to understand that their decision is their decision. And it's also a good way to point out an issue because you're the one who's going to be affected by it. You're the one who's going to have to pick up the pieces in the time of crisis. And if you can't get a hold of your brother who lives in Florida, then you may want to point that out as an issue to your parents. And I find that most parents are very responsive to this. They don't want to be a burden on their kids. They really do want to make things easier on you. So if your mom still insists on having your older brother as a trustee or an agent for medical decisions, you may want to strongly encourage her to name one or two alternate agents or trustees, just in case your brother can't take on that responsibility or doesn't want to take on the responsibility. Also make it clear that these documents will allow your parents to be in control. They get to decide who's in charge of their medical decisions, who's in charge of their finances, and ultimately who will inherit their estate or their legacy. You can also say, we'd like to understand what your wishes are so we don't have to be guessing. I'm sure you don't want us, your children, arguing with each other because we don't understand your wishes about your care, your finances, or who you wanted to be in charge, who your agent is supposed to be, who your trustee should be. Impress upon them that if they fail to make those decisions, the court will decide those issues for them. And it may not be the decision that they would have made for themselves. And also remember, every family is different, and as a result, there's no fixed way to have these conversations with aging parents. What is crucial is that the conversation happens before it's too late. Unfortunately, life often doesn't give us a lot of warning, and life happens. While you and your parents are both physically and mentally able to do some of these discussions, now is really the only reasonable time to get it done. So I'd like to thank you again for attending the webinar. It was a pleasure speaking to you, and I hope that you learned something helpful today.
Great, Christine. Thought it was very, very, very thoughtful and I think very relative. For me personally, for some of the people on the call, they may know that I've been a caregiver and I have a parent, a mother who was diagnosed with dementia several years ago, and we went down this road, my siblings, my brother and sister, and myself, and going through this whole process was very difficult because while we had some of these things in place before, there were a lot of other things that we weren't quite prepared for. And I know for a fact that all of the things that you talked about are so relevant and so true, and especially in our case, in our family, we were all on the same page with how we wanted to care for our mother. But in so many families, there's so much discord and disagreement and competitiveness, unfortunately, in a lot of instances about how to deal with, our parents' care. So I thank you very much, and everyone here. Christine is awesome. She's working with several of our clients, and we are open to taking any questions that you guys might have. You can use the chat box. But Christine also is going to be providing each one of the registrants a booklet. Did you want to talk a little bit about that, Christine? Because we will forward it on to everyone for you.
Yeah. As a result of my practice, I've come up with an e-book on a number of legal issues that caregivers face taking care of their parents. So hopefully it will give you some guidance and some useful information that will help you take care of your parent or any other elderly loved one that you are responsible for.
Great, great. All right. Thank you so much for your time today. I know you are extremely busy. And for everyone else that came on our call today, we thank you for being on. We look forward to having you on the rest of our calls, especially for the Aging in Place series, but also our upcoming webinars. We'd love to have you on there as well. So with that said, thank everyone for being on the call today. We will, Christine will actually be in contact with each one of you via email to send on that information, and feel free to reach out to her for any consultation as well. In the meantime, have a prosperous day.